I rise to speak today on the Parks Crown Land Legislation Amendment Bill 2019. Over the past few weeks, many constituents have raised the same question. What does this bill mean in reality? Well, first, it's important to note that under the existing legislation, the public can currently access licensed river frontage for recreational activities such as fishing, picnicking and hiking, but as it stands, this excludes camping. The licences that the bill refers to are Crown frontage licences. Licensees pay $68 for this privileged position, and it enables them to use the Crown land and the river frontage for a specified purpose such as grazing. The aim of granting such licences is to improve the water quality, control erosion, improve farm productivity and support the native environment. To be clear, a licence does not remove the public right to enter and remain on this land for approved recreational purposes such as birdwatching and fishing. What this bill proposes is to extend that right and enable camping on licensed Crown land river frontages. In summary, this bill is committed to guaranteeing access to fishing and camping on Crown land that has grazing licences and river frontage. In reaching my decision, I look towards the current arrangements in state forests with licence holders. Currently, in state forests where camping is permitted, farmers with grazing licences and campers use these areas in harmony. To my knowledge, there has never been an issue with this, and I cannot see how extending this to Crown land would result in anything but a win for the public. In reaching this conclusion, I acknowledge that people have been illegally camping on Crown land for years. In order to better regulate and manage this, it is important that appropriate mechanisms and policies are implemented. I wholeheartedly agree that a thorough public consultation process on the draft regulations is needed, as licensees and local landowners will be affected. In particular, it is essential that proper regulations are put into place to manage disposal of waste, campfires and other environmental protections. As a community, we have an obligation to promote and engage in good camping behaviour. We understand the effects of bushfires and the impact that littering has on our local wildlife. To mitigate this, the proposed bill will make it an offence to leave campfires and barbecues unattended on licensed water frontages on regulated fire areas, including the state forest, protected public land or national park. In addition, the size of the campfire and barbecue, as well as the area surrounding them, will be regulated to ensure sensible and safe camping. Further, to uphold the regulations and to ensure that campers act responsibly, I acknowledge that the fisheries officers, Parks Victoria Rangers and authorised officers from the Department of Environment, Land, Water and Planning will be and must actively police the behaviours of campers and licence holders on Crown land. In addition to this, the public will be able to report illegal behaviour to a 24-hour hotline. It is clear upon reading this bill that it proposes sufficient policing, management and community consultation to properly implement regulations that consider the impact of camping on locals and licensees on Crown land. In addition, the bill also provides to create and modify several parks, reserves and conservation areas around Victoria. The creation of the landscape conservation areas will provide necessary protection to our native flora and fauna, to better educate local communities on Indigenous vegetation and habitat, as well as Victoria's natural wildlife. Landscape conservation areas will be allowed to include dedicated community use and education areas. The creation of the Yallock Bullock Marine Coastal Park will see several existing parks, reserves and Crown land merged together to better facilitate and manage visitors drawn to our coasts. The inclusion of additional visitor facilities will not only boost the local economy, but also enable the local community to better enjoy, experience and learn about their local environment. As has been mentioned, initial and ongoing consultations with the community have been positive and will ensure that this area remains environmentally sustainable for the local wildlife. What is reassuring about the proposed modifications and creation of parks, reserves and conservation areas is the inclusion of express instructions on how they are to be managed and regulated. It is important that our native landscapes are preserved and protected from imported flora and fauna. Further, what is particularly important is the proper and sufficient measures are taken to protect our wildlife and their habitat from fire. Victoria's devastating history with bushfires has taught us that we need to do better to maintain and manage our natural environment. As such, I am pleased to see this has been included in the landscape conservation areas. In summary, upon reading this bill, I believe it proposes sufficient protections, regulations and mechanisms to ensure Crown land, parks, reserves and conservation areas are maintained. In addition, it proposes significant benefits for the local wildlife, Indigenous flora and fauna, as well as enable the local community to enjoy, experience and learn about nature in a safe and a regulated format. It is on this basis that I commend this bill to the House.